Hey everyone, and welcome to today's Explainer. We're jumping straight into a total heavyweight for the Trademarks Agent Exam 2027 syllabus. We're talking Lecture T4, which covers assignment, transmission, and the whole registered user system. We are going to break down sections 37 through 45 and 48 to 56 of the Trademarks Act. Let's figure out how to actually make these concepts stick in your brain for exam day. So let's kick things off with a scenario that examiners absolutely love to throw at you. Picture this. A company sells off its trademark, but they completely leave behind the actual business. They keep the factory, they keep their staff, but they sell the brand itself. 6 months roll by, the new buyer tries to officially record this assignment, and the registrar just flat out refuses. Why? Well, it's because of Section 42. You see, an assignment made without goodwill has literally zero legal effect until the assignee gets specific directions from the registrar and advertises it. It is a mandatory condition precedent. Basically, no advertisement, no assignment. Here's our roadmap for today. First, the power to assign. Then restrictions on assignment, followed by the Section 42 advertisement trap. After that, we'll hit special marks and title, break down registered versus permitted users, and wrap it all up with a rapid-fire exam recap.
All right, part one, the power to assign.
This is where we see a really monumental shift in trademark law. Section 37 sets the baseline. Only the registered proprietor, the person currently sitting on the register, actually has the power to assign the mark. But take a look at Section 38. This was the 1999 Act's big game changer. A registered trademark is now assignable with or without the goodwill of the business. Under the old 1958 Act, you couldn't just sell the mark all by itself. But today, it's an independent, fully tradable asset. And it gets better. Section 38, subsection 2, allows for partial assignment, meaning you could assign your mark for Class 5 pharmaceuticals to someone else, but keep Class 30 food products entirely for yourself. It's perfectly valid. Oh, and Section 39? That grants this exact same freedom to unregistered marks too. Moving right along to Part 2, restrictions on assignment. Okay, pay close attention here, because this distinction is exactly where examiners set their best traps. It's absolutely crucial that you understand the difference between Section 40 and Section 41. Section 40 is all about goods-based confusion. You can't assign identical marks for the same goods to different owners. If you try, it's void. But there is a lifeline. Under Section 40, subsection 2, the registrar can consent to an exception if they are convinced that no real-world confusion will actually happen. But then you have Section 41. This deals with geography-based confusion, like trying to split ownership across different parts of India. Spoiler alert, India does not allow regional franchising of trademark ownership. If you try to assign the mark for North India to one person and South India to another, it is void. Period. And unlike Section 40, there is no registrar exception possible here. It's just a total, absolute prohibition. Which brings us to Part 3, the Section 42 advertisement trap. Remember that hook from the very beginning? If you assign a mark without the goodwill of the business, Section 42 triggers this mandatory sequential flow. Step 1, the assignee has to apply to the registrar for directions on how to advertise. Step 2, the registrar tells you exactly which medium to use, like the Trademarks Journal or a specific newspaper. Step 3, you have to advertise exactly as they directed. And Step 4, you have exactly 6 months to get this whole shebang done. And just to prove this isn't a joke, the IPAB ruling in the Nico Quality Products case confirmed this is a mandatory condition precedent. It's not just some procedural red tape. If you skip this and try to register your title straight away, the assignment is legally dead in the water. Next up, Part 4, special marks and title. Now, special marks play by their own special rules. Section 43 says that a certification trademark, thing along the lines of a wool mark or an ag mark, can only be assigned with the prior consent of the registrar. Why? Because these marks carry a huge amount of public trust, so the registrar has to make sure the new owner can actually maintain those certified quality standards. Then we've got Section 44 for associated marks. These are similar marks for similar goods owned by the same person, and they can only be assigned as a whole package. You can't split them up, because doing that creates the exact kind of confusion Section 40 is trying to prevent. But here is your exam escape route. If you are absolutely desperate to assign just one associated mark, you have to officially apply to dissolve the association first under Section 16. Only after they are legally separated can you assign them individually. So keeping all that in mind, there's a magic number you really need to burn into your memory for the exams. 6. Once you acquire the title to a mark, you have exactly 6 months to apply to register that title with the registrar under Section 45. You're going to do this on Form TMP. Now, the registrar does have the discretion to extend this by another 6 months if needed, but 6 is your baseline anchor. Don't forget it. Let's shift gears to Part 5, registered versus permitted user. This right here is arguably the most important comparison in the entire licensing chapter. When someone is a registered user, they are formally registered on Form TMU under Section 49. Doing this basically grants them two statutory superpowers. First, under Section 48, their use of the mark is deemed used by the proprietor. What does that mean for you? It means if a competitor tries to cancel your trademark for non-use under Section 47, the registered user's activity literally shields and defends the brand. It counts as your use. Second, a registered user can actually sue for infringement in their own name under Section 52. Now contrast that with a permitted user under Section 2, subsection 1, Clause R. This is someone who just has a private, written contract. They aren't on the official register at all. And crucially, they get zero deemed use protection, and Section 53 expressly bars them from starting infringement proceedings. Simply put, they cannot sue. But hang on, there is a catch for a registered user's right to sue, and it revolves around the number 2. Section 52 requires a mandatory 2-month notice period. Basically, the registered user has to formally call upon the proprietor to take action against the infringer first. Only if the proprietor refuses or just neglects to act for 2 full months can the registered user finally step up to the plate and sue in their own name. I know memorizing fees can be a total headache, but check out this awesome memory trick. To record a title assignment, you use Form TMP, which carries an e-filing fee of 9,000 rupees. For a registered user, you use Form TMU, which is 4,500 rupees. The logic is beautifully simple. The fee for merely licensing someone else to use the mark, Form TMU, is exactly half the price of permanently transferring it on Form TMP. 9,000 sliced right down to 4,500. Just to quickly wrap up the user rules, let's run through the control mechanisms in Sections 50 to 55. The registrar holds a lot of power here. Under Section 50, they can cancel a registered user registration, suo moto, meaning on their own initiative, if, say, the proprietor just isn't enforcing quality control. Section 51 lets the registrar demand info about the agreement whenever they want. Section 54 is highly tested, so take note. A registered user's rights are strictly personal. They cannot assign or sublicense that right to anyone else. No exceptions. And finally, Section 55 tells us that using one associated mark actually counts as using the other, which is just another great defense mechanism for your brand. All right, let's bring it all home with Part 6 rapid-fire exam recap. Let's test ourselves against some traps pulled straight from past year questions. You ready? Can a registered mark be assigned without goodwill? Yes, absolutely, under Section 38. What if an assignment creates identical marks for the same goods but with different owners? That's void under Section 40 unless you get registrar consent. What about a territorial split within India? Absolutely void under Section 41, with no consent possible whatsoever. When does an assignment without goodwill actually take effect? Only after the registrar's directions and advertisement under Section 42. What's the timeline to file Form TMP? Exactly 6 months. And finally, can a mere permitted user sue for infringement? Never, under Section 53. To wrap up this explainer, I want to leave you with one final strategic question to chew on. Can your brand survive a Section 47 non-use cancellation attack if your licensee is merely a permitted user and they aren't officially registered on Form TMU? The answer is a resounding no. And that highlights exactly why taking that extra step to formally register users is just a completely non-negotiable strategy for any smart trademark agent. And that covers our deep dive on assignment, transmission, and registered users. We are now perfectly primed to tackle Lecture T5, where we'll get into cleaning the register and that dreaded Section 47 non-use removal. Keep studying smart, and I'll catch you in the next explainer.